Hi, my name is Howard Kline and I'm the Trademark Department Manager at NAF Goldberg & Meyer. Today we're going to be discussing office actions, what they are, and why you receive them. When you file a United States trademark application, the application will be examined by an examining attorney at the Trademark Office around 3 months after the filing date. The examining attorney, when they're examining the application, will look at a number of factors. Some of them include 1. Does your mark create a likelihood of confusion with an existing registration or a pending mark? 2. Is your mark merely descriptive? 3. Are your applied for goods and services compliant with the U.S. Trademark Office standards? 4. Are there any elements of your mark that are so descriptive and/or generic that they must be disclaimed from your mark? And the last issue that we mainly see is, does the examining attorney need any further information from you in order to properly examine the application? When you receive an office action, you generally have 6 months to file a response. Many times, these responses are pretty straightforward, and if it's a minor issue, such as the identifications of goods and services, what our office can do is we can really just call the examining attorney, get a better idea of what they're looking for, and either just simply resolve the issue over the phone or get a better idea so that we can file a response so that you don't receive a final office action. If you receive a likelihood of confusion refusal or a merely descriptiveness refusal, in that case, you'll need to prepare what's called a substantive response to office action. These responses are generally best left to attorneys so that they can analyze the issues and prepare a full comprehensive response. When you submit a response to office action, you can include evidence that will go on record. And when you submit that office action, the examining attorney then has to make a determination about whether they agree with your position or if they still maintain their refusal. If they maintain their refusal, you'll receive a final office action. Upon receipt of a final office action, you have a 6-month period to either file a request for reconsideration, allow the mark to go abandoned, or file a notice of appeal to the Trademark Trial and Appeal Board. It's generally best practice to file that request for reconsideration if you want to get more evidence on file. And when submitting that request for reconsideration in connection with it, you can file a notice of appeal in case the examining attorney maintains his or her refusal. If they maintain their refusal, you can then appeal it to the Trademark Trial and Appeal Board. If it's a likelihood of confusion refusal, please keep in mind that the odds of success are generally quite low, anywhere between 5 to maybe 12% chance of success in overcoming that refusal at the Trademark Trial and Appeal Board. However, if it's a close case, it's our general recommendation to really file those responses to office actions, speak with the examining attorney, and try to really come to a mutually agreeable solution. Sometimes that includes deleting out some goods. But if the examining attorney is really strict and you just disagree, you do have an option of pursuing a consent agreement. A consent agreement is really reaching out to the owner of the cited mark and seeing whether or not they'd be open to agreeing to mutually register both marks. And that's something that we'll discuss in one of our later videos, but a consent agreement is often one of the best options because it avoids costly litigation. It reduces the likelihood that that party may come after you in the future. If you have any further questions about office actions and strategy, please give us a call, 703-548-6284. In addition, we can be reached by email at ip@naflaw.com.